Everyone, and happy Friday. It is a beautiful day where I'm at, and welcome to another edition of Ask an Attorney Live. We do these every Friday at 11:30, and I discuss different areas of law or different obligations of an attorney. Um, so, I used to report almost every week on what was happening with COVID, and I didn't do that for a couple of weeks, but I thought I'd check it out again. And from what I'm seeing, according to the Texas Medical Center website, is our cases are going down. Hospitalizations are going down. We are still at a higher level than we were in April and May, but we are much lower than the spike we saw in June and July. So what everybody's doing seems to be working and helping, and we'll see how kids going back to school affects the whole thing. But just keep being safe and being smart and enjoy your lives. So today I thought I would talk about confidentiality and what that means between an attorney and their client. So attorneys and clients have a privilege of confidentiality. That means anything that you talk to with your attorney is covered by what we call an attorney-client privilege. So any information that you share with your attorney can't share with anyone unless certain factors have been met, such as your attorney can talk to you and get your permission to discuss it. If it's necessary to further your case and to help you progress in the case and for your benefit, then an attorney can release confidential information that you've shared with them. Um, One thing that I would really caution anybody about is we can release information to anybody that you give us permission. At Boswell Law Firm, for instance, we require that you give us a written authorization to discuss your case with a family member or a friend or anyone. Just know any conversations that an attorney has with somebody that is not their client are not covered by the confidentiality um, clause. And so those conversations can actually be discovered by the other side. If they were to put that third person on the stand, they don't have the ability to claim an attorney-client privilege because that is not the attorney's client. So you want to be very careful of who you release information to, because it could be conversations about delicate issues on your case are released, and the other side finds out about them, and then they can get around the confidentiality requirements of the attorney-client privilege and access information that they wouldn't necessarily be able to access otherwise. So, I get contacted sometimes by family members out of concern, and I can completely understand that concern. But unless a client has specifically released us to discuss the case with anyone, then we are not allowed to do so. And it doesn't matter who's paying the attorney or hires the attorney. What matters is who the client is on the employment agreement, and that's where that attorney-client privilege comes in. It also extends to what we call work product for an attorney. So that's anything that an attorney creates in furtherance of the case in order to trial. A lot of times we do evidence charts or other things that are useful for us, and those items are covered by the privilege of attorney work product and aren't discoverable by the other side. Um, there are some exceptions to attorney-client confidentiality, and that is, if an attorney reasonably believes their client is going to commit a crime, um, they're required to strongly advise their client. But if another person's well-being is in danger, or we have allegations or knowledge of child abuse or elder abuse, attorneys are mandatory reporters. And so if we get that information, we have to report it to the proper agency. And the attorney-client privilege doesn't necessarily extend to those issues. So, if we have a reason to believe it's necessary in order to prevent the client from committing a criminal fraudulent act, we can do that. We can seek help for them. Um, so we also have information that we get from clients that are medical records. Attorneys are covered by HIPAA regulations, which means we have to be very careful in the obtaining of medical information. We have to be careful in storing the medical information, and we have to be very protective. So because we fall under HIPAA, we have to have releases to provide medical information of our clients to anyone. That includes the other party in cases. So we have to have releases from our clients in order to provide medical records or a court order causing us to do that according to HIPAA. It's also when we get medical records of the opposing party, we also have a duty under HIPAA to not release those to anyone. So I would strongly encourage attorneys to know the HIPAA regulations and what they can and can't do with medical records, even medical records that are produced in discovery. So to prevent getting yourself and your client in trouble, you might want to know those regulations, because as attorneys we are bound to follow HIPAA regulations. There's a training that all attorneys are supposed to do with themselves and their staff in order to be familiar with HIPAA and the regulations required thereunder, and that's something that I take very seriously, and hopefully all of my colleagues do as well. So some other reasons an attorney can break confidentiality is to protect themselves in any kind of a claim of wrongdoing. So if a client ever files a grievance with the state bar or files a malpractice claim, they are effectively waiving their client privilege in regards to any communications or information the attorney has that the attorney needs in order to protect themselves against those claims. Let's see what else. And I'm looking over here on another page. I think that pretty much covers it. So my best advice to anybody is consult with your attorney and know your rights as far as confidentiality and protection of your medical records and information. And that you encourage family members, friends to understand what that confidentiality means and what breaking of that confidentiality can mean as well. If you have any questions, as always, just reach out and I'll be happy to answer them. It doesn't cost me anything. There's no obligation. I just want to make sure that everybody is well informed and that they can protect themselves with a little bit of knowledge that I can share. So anyway, if you have any questions or concerns or just want to reach out and ask a question, I'm always happy to get questions and to answer them here each week. And you can contact me at my email, which is Duana, Duana, at boswelltexaslaw.com. You can also message me right here on this video, and I will respond as soon as I get them. Anyway, I hope everybody enjoys their weekend and stays nice and cool while being able to maybe enjoy a little bit of time outdoors. And stay safe, and we'll see you next week. Thanks, everyone.